everyone. Welcome to The Presumption. I'm Sarah Azari here with my buddy Jim Griffin, who I call Jimmy G.
Hey, Sarah.
And Matt Fondelier, our beloved producer.
What's up, guys? Looking forward to chatting with you.
Yeah. So we're continuing our conversation about the Alec Murdaugh case with the man himself, Jim Griffin. And one of the things that was really sort of maybe simple, but ended up being really in the weeds and convoluted for people to understand, certainly not for TV segments, is this infamous Facebook post. The Facebook post that was supposedly made by a dismissed juror that was essentially pro-defense, is my understanding, and that Clerk Becky Hill was behind the dismissal of this juror, bringing to the court's attention after interviewing the juror herself, which is inappropriate, that, hey, she has a husband with whom she's spoken to about how she's going to vote in this case or something like that. So, Jim, let's start with the post, the supposed post, and then the fact that whether it existed or not. Can you tell us about this post and why it became an issue for Becky Hill?
Oh, good grief. So the post, allegedly, this juror's ex-husband posted on some Facebook page, Walterboro Word of Mouth or something like that, that he had gotten met up with his ex-wife, the juror. They got drunk, and the ex-wife, the juror, was confiding into him that she believed Alex was innocent. Mm-hmm. Big deal, right?
Yeah, big deal.
Big deal. So she brings that to the judge's attention, and we all say, "Where's the post?" And then they go look for the post, and they don't find the post. They find
an apology.
They produce an apology post by someone who has the same name as this juror's ex-husband. Convenient, coincidental. I don't know, but
his name is Tim Stone. I mean, it's pretty common.
Well, who knows? But okay. They produced the apology post, and it was sort of during the trial, and there was a collateral issue going on with the same juror, and this Facebook thing was just sort of floating out there, and nothing really ever happened about the Facebook issue. You'll recall, or you people may or may not know, but at the same time, there was an email that came into the clerk's office from someone who was a co-worker of a tenant of this same juror, who says that the juror had delivered a refrigerator and they had some conversation about her jury service. Well, that night, when all this is going on at the same time, that night SLED goes out and interviews these two tenants. But as I've sat back now and had an opportunity to reflect, and we've investigated more about these Facebook posts, I find it really, 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 really curious that SLED never went out and tried to interview the ex-husband, mm-hmm. who was supposed to be drinking with her, she was supposed to be drunk and telling him that, that Alex is innocent. SLED mm-hmm. never tried to interview that person, and you wonder why. So, we've been trying to bird dog this apology post, and we found the guy who posted the apology post by the name of Tim Stone, lives in Jessup, Georgia. He gave us an affidavit. We filed in court today, right. which is September the 18th. And he says, I don't know, I've never been to Walterboro, and he's one of 10 people, Matt, on the planet who didn't even know about Alec Murdaugh's murder trial. I mean, he's
out of Georgia, by the way, according to his
Georgia, and he knows nothing. And his apology post is dated February the 16th, and it talks about a post he took down that he posted on February the 15th. All this stuff going on with the judge and Facebook posts, all that was February the 23rd, like a week later. But
oh my God! So the apology preceded the supposed act of the Facebook post.
Oh yeah.
Right?
So the apology post preceded the nasty post that he apologized for, that he took down, on February the 15th. Now, what we do know, and we filed in court, is Mr. Stone was apologizing for writing a nasty post about his wife's aunt who was meddling in their marriage. It's got nothing to do with Alec Murdaugh's murder trial. It's got nothing to do with this juror. It's got nothing to do with anything. Yet,
and the juror
but you have the clerk's office coming up with these documents showing to the judge and talking about this fictitious post that never happened. And overlay that is, why isn't SLED out there investigating this? Does SLED know? Are they on the inside of this? I mean, these are serious questions that need serious answers. And do you think we'll ever get serious answers to these questions if SLED's investigating their own failure to investigate this bogus Facebook post? I mean, why didn't SLED go out and interview the husband? I mean, they didn't. We've talked to the guy.
I mean, that's what is so unnerving about this, is that SLED is still has his hands in this. But ridiculous. This juror gets dismissed, and my understanding is that the judge was taken aback that Becky Hill had direct communication with this juror about this issue. Was there any indication that the judge was going to address this in any way when he learned that this very inappropriate contact was made with a juror?
Not that I know of, not to us, and there's nothing on the record suggesting that he took any action. So I don't know the answer to that. And
Jim, there's been mentions by many people that this juror was pro-defense. Now, I look for those signs myself when I'm in trial, but what indicated to you that, if it did, I don't know, that this juror may be pro your client?
I mean, you don't know, right? You never know. You never know. But I will say all the jurors were pretty poker faced during the trial. I mean, they really were. And they, this juror though, smiled at, she smiled at Alec when she sat down. She smiled at her defense table, not directly at Alec.
Yeah.
I mean, and so, we felt good about that. And she wasn't like, looking, nasty at us. And so, we thought.
Maybe she thought you're hot, Jim.
Yeah, no.
Or maybe she thought Dick was hot. I don't know. Maybe she had the hots for you guys.
According to Becky Hill's book, Dick was bloated during the trial because he was on steroids, and I was neutered by Dick. So she couldn't have been me or Dick. I mean, maybe it was Phil. Maybe it was Phil.
Maybe it was Phil. Phil's a good-looking guy too. Yeah.
But she would, give us facial gestures. But here's another disturbing thing is, we finally get, back and we start exploring the issue of the Facebook, the issue of the tenants, and then it evolves. And at one point in time, her ex-husband actually did try to call her because I think he's caught wind of this. And according to this juror's affidavit filed we filed, her sworn testimony is that she told Becky that her ex-husband tried to get in touch with her, and Becky told the juror that the Murdochs have obviously gotten to him. Now, why she would say such a thing, that's what the juror swore to us and on paper in an affidavit, that Becky told her that. Well, so we didn't know that, but we do know that the juror is back there talking to Judge Newman and on the record, and she says, and I believe the Murdochs are kind of behind this. Well, when she said that, that's not a juror we want. I mean, if she's suspicious that we're out trying to interfere with her personal life.
Yeah.
I mean.
And, for our viewers, let me just remind you, it takes a unanimous jury to convict, and it takes one juror to hang. And often hanging the jury is a victory for us. That is why this matters. One of the many important reasons why this matters is that one juror could have made a big difference in justice in this case. All right, you guys. Yeah.
Just one thing. I mean, that's going to be some confusion about the legal standard. We'll be fighting about the legal standard, but heretofore the law has been if the subject of the communication is material. It's not did it make a difference, but could it have made a difference? Then you get a new trial, and this is.
Why do you think there would be confusion? What would be the alternate standard that would?
Well, there's no confusion in the law today, but what we're seeing legal advice being given on Twitter X or whatever, and I'm sure the state will take the position that that
some other weird standard from Mars.
That we have to prove it did make a difference, and that's not the standard. Hasn't been the standard, and shouldn't.
What if they come back and say you need all 12 jurors to give you affidavits? No, they have to be unanimous with respect to what they say about Becky Hill.
One more thing on that. You mentioned that and what that sworn affidavits say is that the clerk was sort of keeping tabs on where people stood. And so I don't know that it makes sense that she would really go lobby pro-prosecution jurors at all. I mean, they're pro-prosecution jurors.
Right.
If she's going to lobby anybody, she's going to lobby the fence sitters.
That makes sense. Makes sense. She targeted the ones that would make a difference for you,
Right. And that's what, we believe happened.
All right. Well, we are going to continue this conversation, Jim and I, with Matt, about Murdoch, because like I said, I think it's Pandora's box. There's going to be a lot of things happening. Murdoch's going to be pleading to the federal financial charges. There's the trial set November 27th. We will be really digging into that, not Jim, but me. And so in between those two, there's going to be a lot of issues that relate because there's an overlap, obviously. And so these are the same charges that he's going to trial on, that he's going to be pleading to. Anyway, there's going to be a lot to talk about. And so Jim and I will follow this, and except for during the trial, you will not see Jim. Please stay with us during this short break, and we will be right back. Welcome back from a brief break to The Presumption. We've got Jim Griffin. Hi, Jim.
Hey, Sarah.
And Matt Fondelier and me, and we have a very special guest. I know I keep saying special, but he's special because this is the first time, guys, I think we have somebody from the South with us, right?
Well, from South Carolina, for sure.
Well, from South Carolina, Joe McCulloch.
I don't know if you count Florida as being in the South. I don't, but
it's like weird
South. Who was on here from Florida?
Well, we had Ehrenberg, right? Is he from Florida?
Oh, that's right. That's right. Yeah. Ehrenberg is everywhere, though. Ehrenberg is everywhere. But Joe, you're our first big guest from South Carolina in the South. Welcome.
Well, I am glad to be here.
And thanks for getting dressed and getting out of bed. I know that this is not apparently normal for you. I know. So, Joe, a lot of our listeners and viewers are familiar with his face because during the Murdoch trial, he was very well positioned, and the cameras were always showing him on. There he is, right behind Dick Harpootlian. So, but Joe is a senior lawyer. I don't like the word senior, but anyway, senior partner maybe in the Columbia-based law firm McCulloch, and is it Scalacci, attorneys at law. He graduated from the University of South Carolina Law School in 1977 and worked with the Supreme Court and as a career criminal prosecutor with the Fifth Circuit Solicitor's Office, which is the equivalent of a district attorney's office in some other parts of the country. Joe thereafter served as associate general counsel with the University of South Carolina, later going into private practice in the areas of criminal defense, civil litigation of all types, and sports and entertainment representation. Joe has taught classes in sports and entertainment and wrongful convictions at the USC Law School. Mr. McCulloch served as president of the South Carolina Criminal Defense Lawyers Association and established the South Carolina Palmetto Innocence Project. So, Joe, there's so many there's so much in your expertise that obviously we're trying to fit into this hour, but the first thing I wanted to talk about is Jim was sort of giving me Joe McCulloch 101 and brought up this fascinating case that you had where literally both counsel on both sides got shit up in your lingo. State versus Quaddlebaum. And it was a death penalty case from the 90s, provoked a lot of, violence and death threats and slashed tires and things of that sort. And it's so dynamic because it involves media, prosecutorial misconduct, polygraph. I mean, everything is in this case. So I'm just going to let you take the mic and tell us what this case was about, what your involvement was, and what ended up happening, because I think it raises a lot of fascinating issues.
Sarah, this began with, I was at a cocktail party. The public defender told me she was overwhelmed. I said, well, how about I'll take one, just get me appointed as a favor, just make sure it's interesting, because this was in a county with a prosecutor who was known as Mr. Murder, or Mr. Dr. Death, I think was this prosecutor's proud nickname, because he had put so many people in the electric chair. So became involved in the case. It was a murder case, involved a burglary and the apprehension of a suspect based on a partial tag the same evening of a housebreaking murder of the owner of the house. And he went to the sheriff's department voluntarily with a lawyer, was questioned, was asked to take a polygraph as his story began to collapse. He was placed in the polygraph room with his lawyer to have a private, privileged conversation. Unbeknownst to them, down the hall, the deputy solicitor and about half the police department were all crowded into a room listening to the conversation and recording it. A year later, just prior to the trial, that tape surfaced, and then suddenly it was on the news because someone had leaked the tape to the local TV station. So,
who leaked it?
Well, ultimately, it was discovered that the first lawyer who had gone to the jail to accompany the suspect leaked it. He eventually lied to the grand jury and was spent a little time in prison. He's a good lawyer, smarter lawyer than that. Still don't understand why he did that, because he was well aware that I was in the middle of a process of filing motions to hold the prosecutors accountable to get the trial continued. What then ensued were a series of arguments in court about the tape, demands for an FBI investigation to circumvent SLED, because I was concerned about that relationship, and also a trip to the state Supreme Court to get a prior restraint order to try and shut down the media's use and playing of this video, though they had up until that point agreed not to play the audio, which is the kind of audio as a criminal defense lawyer you don't want your client being heard to say.
Right.
I was at least successful in getting the court to order that no one could play the audio. The video was out of the bag, as they say. So ultimately, the FBI began an investigation, but their interest really was only about who leaked the tape, not how the tape was made. We went to trial. Eventually, he was found guilty of murder, sentenced to death in less than an hour after a multi-week trial. Deliberation.
Is this your client or the co-defendant whose privileged communications were recorded?
No. It was not a co-defendant. There was only one defendant here.
And it's only one defendant.
Yeah. The suspect crossed the Rubicon of suspect to defendant when he walked out of the polygraph room. They were waiting there with handcuffs, did not reveal that they had been listening to the conversation, but based on that conversation, they immediately charged him. A year later, the Supreme Court found that the judge had erred, and the judge is a great judge. He should have allowed me to cross-examine the prosecutors in the case. He should have allowed a series of things. I mean, the case, State versus Quaddlebaum, I'm very proud of. It stands today as the leading case on prosecutorial misconduct. It resulted in the federal indictments of the district attorney and several cops. And so I'm very proud of that case.
Go ahead,
Joe. I'm, part of our focus of this podcast is, the media influence on high profile cases. And I'm just curious as to, without naming names, but the lawyer who originally represented Mr. Quaddlebaum, who learned about the tape, do you know what his strategy was by leaking it to the media? I mean, it's his own client's confession, I take it.
Jim, the best I can tell you is from the conversations I've had is that he felt unwisely that embarrassing the prosecution by leaking it to the media was a good idea. He should have understood that I was going to go after this with a gusto as I did, and the embarrassment was going to occur by reason of the filings and the arguments in court. Why he ultimately he was subpoenaed to a grand jury that was convened to figure out who leaked the tape, not convened to determine how the tape was made, and he didn't tell the truth.
Now, I understand this was a federal grand jury. I mean, that was, I found that shocking, is that the federal government starts to investigate who leaks the tape and not how this defendant's civil rights were violated. I mean, that is.
Well, 2 FBI agents showed up in my office shortly after the tape was leaked and threatened to indict me, said, "You're going to be indicted. We know you leaked the tape." And I said, "Get your ass out of my office." I didn't leak the tape. And I'll be happy to take a polygraph right after the solicitor, our district attorney, and the sheriff of the county, who are all, to a degree involved. Right after they take the polygraph, I'll be third in line. Now get the hell out of my office.
Well, I have a question. Look, us in this room, in this studio, thankfully, are not guilty of this. But there are lawyers, and I won't name names, and some that sometimes end up making decisions when it involves media attention on a particular case that are self-serving. Do you have any reason to believe that this lawyer may have leaked the tape for just the media around it, or you think that it was just really a bad strategy call?
No, I don't think it was that.
Okay.
He didn't go on television. He didn't do the victory dance that we've seen in this case. He simply made a terrible judgment.
Yeah, horrible judgment, because he could have accomplished the messaging without leaking the tape, frankly.
Well, had he spoken to me, I would have assured him. In fact, I did tell him I'm working busily all weekend on a motion that's going to blow the courthouse up. So he didn't bother to consult with me about leaking the tape, which I would have said was a bad idea, because not only did it distract me from preparing the motions, I had to go to the state Supreme Court on a writ to get a prior restraint order, which is nearly impossible.
It is. Now, I know a lot about this case because I followed it very closely, but an interesting part, Joe, if you could explain, the tape was given to a TV reporter whose husband was a DEA agent. Was that it?
That's correct.
And that's how it came out. Who leaked the tape, right?
Well, the FBI went to see the TV station, and of course they asserted source privilege. They said, "We can't tell you, you can't subpoena us, you can't make us. No rubber hose treatment will get the source of this tape out of us." Unfortunately, the FBI somehow managed to work their way to her husband, who was a DEA employee, and pressure was put on him to take a polygraph. And unfortunately, as facts unfolded, he had gone with her to receive the tape. So he watched it being received, knew exactly how the tape had bounced from its creation to our discovering it and then ending up at the TV station.
Now, Joe, you're pretty much a Renaissance man. Honestly, you wear so many hats, and you know so much law in so many different areas. I mean, you teach entertainment and law at the law school, but you went to the Supreme Court and got a prior restraint order, which butts up against the First Amendment. I mean, tell our folks about First Amendment rights of the media and how you were able to pull that off.
Mm-hmm.
Well, logically, and thank God, the Fourth Estate has pretty much the right to publish and receive and investigate materials, and the right not to have to reveal the sources. And that's the great protection of all of us from government, and that, is subject to erosion. So getting the Supreme Court to restrain the media from doing anything is very difficult in this country, easy in some other countries. But I found myself arguing United States of America versus Noriega and some other U.S. Supreme Court cases in which prior restraint under circumstances involving national security and so forth. But I mean, there's a long history of the difficulties of prior restraint, like the Pentagon Papers and Daniel Ellsberg. But happily I was successful. This was the ultimate collision between an accused's right to a fair trial without his statements made in privileged conversation not to be aired on television or in the media.
It's insane. Oh my God. I mean,
and just to
quite a case.
Just to close this out, the assistant DA or assistant solicitor lost his license, did he not, to practice law for a period of time?
He was suspended for a year. The police officers were prosecuted with not much consequence. I think they received fines. But, we have a long history, Jim, as you know, of prosecutorial misconduct, which results in virtually no consequence for our prosecutors. That's a hole in our enforcement donut, I believe, in South Carolina, that we have a kind of a frequently prosecutors not revealing discovery at all, sometimes not until the middle of trial, as occurred here recently. We just had a South Carolina Supreme Court case reversed and remanded, a murder trial, because the prosecution didn't reveal impeachment evidence under Brady, which was critical to the defense of the case. And it results in virtually no consequence for the
But is this because your courts tend to not view this failure as willful, or do they look at it and go, oh, well, maybe the delay was justified, etc., or is it that they just don't care that it's willful and prosecutors are above the law out there?
I can't. It's a case by case. I can say that one of the prosecutors in Mr. Griffin and Mr. Harpootlian's cases recently was accused in a murder trial.
Oh yeah, Mr. Meadows.
Of withholding evidence. I don't know all the facts of it. I'm waiting to see the transcripts, but I understand that a lawyer from the U.S. Attorney's Office had disclosed the information prior to trial, and it had not been produced to the defense before the trial. And so I hope to encourage a call to arms, asking our Attorney General to look into this problem of prosecution misconduct, and especially in the discovery area, and take action. He's the boss of all those solicitors, DAs we call solicitors.
We just because one of the interesting things about this podcast is that Jim and I work in very, very different jurisdictions. Not to say we don't have prosecutorial misconduct, we sure do, but in terms of discovery, I'm always so grateful when I learn about, I used to bitch and complain about not getting enough discovery, but we are way ahead of a lot of other jurisdictions, including yours. We get so much discovery at the arraignment. We then do discovery requests and they're obligated to turn it over. With respect to Brady stuff, we get notices often about, law enforcement discipline that may or may not even be really relevant. But, it exists everywhere. But I think that we tend to have less issues over, prosecutorial misconduct when it comes to discovery here. Sarah,
let me say this real quick, because it occurs to me. The contrast between North Carolina's treatment and South Carolina's treatment of prosecution misconduct is best illustrated by the Duke LaCrosse case.
Oh, that's right.
Nifong, the prosecutor who basically put upon these innocent young men in the LaCrosse case in that sexual misconduct situation, not only was he suspended, but he actually was prosecuted. I think he served a whole day in jail, but it made the point resoundingly for the lawyers in North Carolina. And, time for our Attorney General to take the gloves off and get about the business of policing his own prosecutors.
Yeah, I think your system in South Carolina needs a whole rehaul. Every time I hear, Jim sometimes tells me stories and I'm like, what? This happened? Like, how is this possible? Just
South Carolina.
Yeah, South Carolina. All right, look, I'm going to turn it over to Jim to talk to you about some very important tips that you have for our viewers.
Joe, I mentioned, you are a Renaissance man. You do a lot of different things. And one of the things that you did early in your career, cutting your teeth on with DUI cases. And people who are listening think a DUI is a traffic stop, but it is really, really a complicated area of the law when it comes to, breathalyzer, blood test. And I want everyone to know that you just completed a 2-week voting under the influence case involving serious injuries, felony, and the defendant was looking at significant time. And you, as I understand it, got all the blood results thrown out of the case, and the defendant was acquitted of all the under the influence involving alcohol. Now that this reckless homicide was involved or something, but that's true, isn't it?
That is true. It was a terribly tragic boating accident in which one boat runs over another boat, kills the driver of the boat, and amputates his wife's leg in the balance. And very serious case, and we were successful with a former partner of mine, actually a former partner of Dick Harpootlian's. When we practiced together as Swirling, Harpootlian, and McCulloch, we tried the case together, Mr. Swirling and I, and we were successful in getting the blood out of the case. We just didn't win it all.
Right. So with that background, so someone gets pulled over on a DUI, should they take a breathalyzer?
And speak slowly so I can take copious notes for my friends, not for me, because I know you don't drink and drive. But
listen, DUIs happen to the best of us. I've represented lawyers on,
They do, Sarah. I've represented lawyers and doctors and airline pilots and FAA traffic controllers.
Right.
It is what we call an accidental crime. Mm-hmm. There are very few people who go out for the evening with the intention of getting themselves drunk and getting arrested. And our laws are geared to make examples in this area. So
what's the limit there?
Well, we're 0.08.
And we are too.
Generally the standard. When I started practicing law 46 years ago, it was a 10.10. Without much scientific evidence, we've reduced it to 0.08. There are some countries around the world who are at a 0.05, and of course the pressure groups, the Mad Mothers, and the other groups that exist for whatever purpose, they wanted to go to a 0.05 or a zero tolerance, no drinking whatsoever.
Well, so when someone gets pulled over, to Jim's point, they're asked questions. Can they not answer the questions?
They can refuse to answer questions. That will get them arrested. But
they'll get arrested anyway.
The truth of the matter is, when you're stopped because a police officer has viewed some traffic indiscretion as simple as weaving within your lane of travel,
speeding,
the officer will pull the person over. If they smell a whiff of alcohol, that gives them cause to ask you to step out of the vehicle. They then may begin a series of questions about where you've been, how much you've had to drink, where you're going, and then ask you politely if you'd like to, not always so politely, if you'd like to come over here and let's do these field exercises so you can prove that you're innocent of driving under the influence. Well, big news, you're presumed innocent, even on the street, even facing a police officer. So at that juncture, unfortunately, most people will say, well, I've had 2 beers. That's further probable cause for most police officers, because virtually everyone says, I've only had 2 beers. So declining to talk about what you've had to drink and where you've been, and simply asking officer, is there a problem? And may I go home? That establishes that at that instance, you are in custody, and that that grants to you certain rights.
Rights.
There is no consequence for refusing to talk to the officer or refusing to answer the officer's question other than the fact you're going to get arrested. But I must say, after decades of doing DUI cases, in addition to all kinds of other civil and criminal cases, the officer's level of suspicion, and they're trained, frankly, to take people off the street and let them sort it out downtown, let people like us sort it out later. Better to get that possible drunk off the street than to allow him to pull away from that stop and have an accident 2 blocks later. And because in that case, the police officer gets sued.
Yeah.
Because he had the chance, he caught, released, and now he's going to be held responsible. So the pressure on the police, I've represented police officers charged with DUI. And
so Matt, did you hear that?
I did. And actually,
is there a problem, officer?
You're right. And you say that before or after you're told to get out of the car. That was the part that I didn't understand. Like, if I'm out of the car now and they are saying you got to start taking these different tests, that's when I would say, is there a problem, officer? And can I go home?
Well, they can't make you take the field exercises. Our law says explicitly that you cannot be required to do that.
It's the same in California.
Yeah, well, I can't. That's why I hesitate to give blanket advice. The question that one of you asked, should you take the breath test? In South Carolina, there's a consequence for refusing to take the breath test.
Here too.
And I assume that to be in the same in the other 50. But
it's a presumption of guilt, and it's a rebuttable presumption, but it's a presumption. And with the DMV, you just lose your license flat out. You don't even get a hearing. But to Joe's point, and I want clarification on this, Joe, is that first of all, the field sobriety test that you were talking about, point to your nose and count to 30 with one leg and all that crap, nystagmus and all that. I've actually, years ago when I used to do more DUI trials, I demonstrated how you fail that sober to a jury. I mean, there's set up. I've never seen anyone pass a field sobriety test on a police report. But what we call a preliminary alcohol screening test, when Jim was asking you, do you refuse a breath test or what are the consequences? Are you talking about that pass test on the side of the road? Or are you talking about the actual chemical test at the station?
South Carolina does not permit portable breath testing at the time of the stop. So we don't have that. California, I understand, does. But I think in the grand scheme of things, to me, and it's generally what I tell people at cocktail parties and what I tell them in my office, performing for the police officer these field exercises, they are geared to failure.
Yeah.
In this case we were just talking about, this case I tried 2 weeks ago and got the alcohol out. We got the blood out. What we didn't get out of the evidence presented to the jury were the field exercises that my client engaged in. He passed the most reliable ones and failed the patty cake test, which is a field exercise unique to boating cases.
What's the patty cake?
Yeah,
show us that. What is that?
Well, it's this, and you do it faster when the officer tells you to do it faster. And
raise your hand.
You're flipping your hand over. Is that what's happening?
I referred to that in the trial as the patty cake Baker man, and then apologized to Officer Baker who administered them. But that's what I call them throughout the cross-examination, and it was nonsensical, and that came through to the jury. So even with field exercises, which they pronounced loudly, our client failed, he was still found not guilty on the alcohol components of the trial. But when you engage in the Q&A, when you engage in the field exercises that are geared to fail, you're building the prosecution's case. Now, It is true, when you refuse to do the field exercises, the officer is permitted under most states' laws to refer to that as some kind of inference of concern that you wouldn't do well. And likewise, when you go down and you're offered the breath test You have the right to refuse it. I just have not ever believed that the consequence for refusing is worse than the damage of giving a breath sample that then could conceivably be used against you if you've had anything to drink and you're driving. I have little confidence in the machines. The machine we use here in South Carolina is a Data Master. The machines used in other states are no better scientifically, though the police officers will testify it's a perfect machine and capable of mistake. Years ago, I went to the manufacturer, took a course for a week, paid a couple of grand for the privilege. And at the end of that process, they set up an open bar and let you drink and play with the machines. And I found that if the harder I blew into the machine, the higher the result. Kind of like going to the carnival and hitting that thing.
Did you pay $2,000 to hang out with other lawyers and drink, or did you pay $2,000 to really do this course?
Well, they didn't serve top shelf, so I got beat on the $2,000.
Joe, listen,
it really was to allow me to deal with the machine.
Do you in South Carolina, do they get, so we have an admonition that the officer needs to read to the driver and give the driver the choice between, it used to be blood, urine, and breath, and now urine is out, so it's just blood and breath. But, sometimes we literally, I hate to say this because I think, it's all about constitutional rights, not technicalities, but it is a technicality. Sometimes if they fail to complete the admonition portion of their investigation form, that's one way we get them. So in South Carolina, what are the 2 chemical tests that you have options of taking?
Well, we actually have 3: breath, blood, or urine.
Oh, you have all 3. Okay. All right.
But you make a good point, Sarah. DUIs are like an onion. The more you peel the layers, the more complex it is. So we have a lot of lawyers that charge a couple of $1,000 for a DUI, and they make it look easy because they don't understand the complexity, and you get what you pay for. So for those of us who actually have studied on this, because we find it fun, these things don't last more than a day, though I did try one that took 3. They're fascinating microcosms of all the technical issues that we as lawyers engage in, evidence, admissibility, science. So that's why they're fun. And that's why I've done them for years.
I mean, I'm glad it's fun for you. I think it's like, it's
the jury trial part that's fun for me.
Yeah. I mean, I had a DUI, a young woman who had a terrible pill problem, and she was in the middle of the roadway in the divider. I think she hit something, and that's what stopped her car. Just fell over her wheel. It
happens.
Saliva all over. Anyway, I got a not guilty proudly because they did not quantify. The sheriff admitted on the stand that, he could have quantified the substance in her system, but didn't. So anyway, the impairment part is, but like you said, it's an onion, and it just, you could, get an acquittal just based on just something that the protocol is not followed or something. You know what I'm saying? It's very different than some of the other things that we do. So
let me ask you, how do officers deal with other substances? I mean, marijuana is legal in most states now, and people get gummies, and you can get pretty ripped on the marijuana that's out there today, and that didn't show up on a breathalyzer, does it?
Nope, we're still struggling with that. That's why I'm sure there are going to be efforts in this next legislative session all over certainly in South Carolina, to require blood to detect these other substances. Mm-hmm. Urine's a worthless test, basically. It only shows the presence and doesn't tell you a variety of things relevant to the prosecution. But that's an issue, and marijuana is ubiquitous. In some states, it's a legal substance to ingest. It is problematic because it can have an impairing impact. But currently, the only vehicle we have for its detection are drug DREs, drug recognition experts, which are super cops, and we used one actually in this case a couple of weeks ago.
Mm-hmm. But Joe, so look, the drugs, when you're talking about driving under the influence of drugs versus alcohol. Even if and when you have this compelled blood test, you still, can make an argument for lack of impairment, because some drugs stay in your system for several days. And that doesn't mean that just because it's in your system and shows up in your blood that you were impaired by it at the time of driving. So that was the issue in my case. But anyway.
So Matt, another takeaway, pot over alcohol every day of the week.
Got it. Done.
Pot over
Consider
alcohol.
it done.
And gummies so that your car doesn't stink. So that's not actually the reason.
Unless you leave the doobie in the ashtray. This is
Don't
not
do that.
good. So you always have to eat the doobie.
Eat the doobie.
Hopefully not have ashes all over your mouth when you get out of the car.
Just part of a joint wrapper hanging out the lip. Yeah.
On the ear.
All right. Look, of course, everyone's going to want to hear about Murdoch from you. This is not a Murdoch podcast. We are here for much bigger messaging. Yes, it's a big case. I know, but we have a deal that we really only talk about Murdoch when there's updates that Jim can talk about, because obviously Jim's counsel of record. But there is great interest in the fun behind the scenes stuff when it comes to your relationship with Dick Harpootlian. You guys are friends. You guys have been partners. You're colleagues on certain cases. So I want you to start out by telling us how y'all met, what your relationship is like, and your work and personal relationship. And then also I have some questions about your involvement with Murdoch.
Well, let's see. I worked for the Supreme Court, left there after a period right out of law school, worked in the area of divorces and family disputes, which I couldn't stand, and was hired by Dick Harpootlian, who was the deputy DA here in town, and his boss, and put immediately in charge of DUIs and judicial entertainment. So I was the judge's driver. And from that point, I've known Dick now for 45 years, I suppose. We ultimately ended up as law partners with Jack Swirling. My experience at that point was a little bit broader than Dick's, because he'd really only done criminal work, criminal prosecution, and criminal defense when we were partners. And he went with me to try a case down in the 14th Circuit, Jasper County. In 1985, it was his first civil case, and we got a couple of $1 million verdict in a county I don't think that had seen anything more than $200,000 at that point. And Dick said, this civil thing's really a pretty good deal. You can make some serious money. And I said, yeah, maybe we should try to do that. And so I've tried more $1 million cases, or cases that resulted in $1 million verdicts with Harpootlian. And he's a tremendous instinctive trial lawyer. And with all due respect to Mr. Griffin, before his case, his involvement in this case began, he and I were fighting like cats and dogs in a big dispute with the hospital and doctors, and we were on opposing sides. And currently we're representing. We have a client that we are representing together. So South Carolina is a very small state. You interact with everybody.
Yep.
And
Joe, you were talking about you and I were on opposite sides of a hospital doctor dispute, right? So not you and Dick.
Although I was really talking about you. I mean,
did Jim kick your ass? Did Jim kick your ass? Like
we all worked it out. Cooler heads prevailed, and it was a good result for both of our clients. And by the way, Joe was on the other side of the Murdoch case. He had Connor Cook, who was
that really
on the boat at the time of the accident. Right?
That shouldn't be lost. I guess there are two things I would say about my relationship with Dick. Lawyers are professional. We get out of bed, the men at least, and we put a pair of pants on the same way every day, and we just go. Any given day, I'm representing victims, I'm suing somebody in a civil matter, or I'm defending someone in a civil matter. And the mere fact that you're on the opposite side of someone you know. I knew all the lawyers in this case. I knew Creighton Waters, Eric Bland, the whole motley crew. I know them all, and it means that we should be collegial, respectful, do our jobs, but do it within the lanes of the rules of professional conduct. And this Murdoch case was a
it also means that you should, when you say professional, that you don't go out and smear each other.
Well, I don't believe that I have ever done that in the Murdoch case.
Not you.
Or in any case. I mean, I revere our profession, which, isn't revered by everyone else. And I tell people all the time when they accuse me of being a shiny-shoed lawyer and using cheap lawyer tricks to get my clients' goals achieved. And I told the press the other day following that trial, if you don't like the job I did, make sure, and when you get into trouble or your husband or wife gets in trouble, go hire a crappy lawyer. Don't get one that's capable of knowing the law and using the law as a lever to get the result that you got hired to get. Nothing improper about that on any level. But my relationship with Dick, with Griffin, has nothing to do. I was busy suing Alec Murdoch until just about a month ago.
You and everyone else. Listen, what you touch on, this sort of cordiality that exists among us, is not just in your jurisdiction. I think it's across the board, especially, I think Jim and I have talked about this before, when it comes to criminal defense. They say we're more civilized than civil lawyers because we're not fighting over money. We're fighting over rights. But just as I'm learning more and more about South Carolina's legal system, it's very close knit. I mean, it's that is, I think, what's different. That we, I'll just say this, like, if I have a lot of friends who are prosecutors and I'll see them socially, but they will never, ever let me pick up the tab or buy a drink or anything like that. And I think that where you're from, it's like, it's like one big party. Doesn't matter what side you're on and who's paying your paycheck. So that's kind of interesting, but you're right in that we actually get better results by getting along, in our cases. So that brings me to Murdoch, right? You were in this trial, you were front and center. Everyone knows you have this amazing head of hair. And it's hard to miss you. But more recently, you have been criticized for representing two of the jurors. And obviously this relates to Jim's motion for a new trial and the stay in the appellate court resulting from the Becky Hill conduct or alleged misconduct. And you have two of the jurors. And so there's a lot of criticism about, Joe McCulloch is best friends with Dick Harpootlian. Oh, how interesting that he's representing these two jurors. So what's your reaction to that?
I could care less.
Well, I know, but can you explain?
Fact of the matter is, I got into this, my representation of Connor Cook began because there was an effort by his family, by the Murdoch family, to pin the tail on the donkey and maybe get Connor Cook arrested for the operation of the boat, a fact that I know that Mr. Griffin has some thoughts about. But my job was to prevent him from being wrongly charged. My involvement with these jurors came about because immediately after the trial, at least one of those jurors spoke with me about making the press go away, that people were climbing over fences and walking through the woods to knock on the door and all of that. But ultimately, my involvement with these jurors is because they, like I believe, that it is critical and crucial to our system for everyone, even the worst of us, to get a fair trial. And their affidavits, their participation with the defense, is because the defense approached them. They referred the defense lawyers, and yes, it was Mr. Harpootlian and Mr. Griffin, to me I explained to these two jurors, you don't have to do this, or you can do it. It is entirely up to you and your conscience. And they ultimately made the decision to give affidavits. There are another juror, at least one more juror, who also participated, who I did not represent, who I think confirmed and corroborated what was said in these affidavits. Ultimately, for me, it's about a fair trial. Even the worst of us deserve at least that. And I'm not talking about the Judge Roy Bean, let's give them a fair trial and then hang them. It's about a fair trial. And if we fail to give that to everyone in our society, the system collapses. And so criticism be damned.
Yeah. Well, listen, that's how I roll. I don't give a shit what they're saying. Look, are you doing this pro bono? Meaning free?
Can't talk about fees. Let's say I'm not going to retire on these fees.
Okay. All right. But
you are doing this podcast pro bono, though. I hope
this
you know.
Podcast.
Hell yeah.
I may buy Joe a drink after.
Oh, that's true.
Today, you know.
Listen, Joe. What if some of these other jurors, Dick was out there saying, "Hey, lawyer up, be protected, so you're not intimidated." What if some other jurors come to you for representation and they just can't afford it? Will you do it for free?
Well, Sarah, I'm not really advertising for other clients, but I'm certainly willing to talk with anybody in this case. And I have said, when asked, why do these jurors really need a lawyer? Is there, did they do anything wrong? If they know of or engaged in conversations? And I would say to that, not necessarily. My suggestion that everybody needs a lawyer in this case is really because I find, as many as I have over the last 4.5 decades, police act differently in interviews with people who are represented. You don't get pushed around. You get a more respectful environment. And actually, because there's a lawyer in the corner taking notes, the ultimate result of that interview is more accurate and truthful. And so I do think that there is a value, whether it's me or someone else. I haven't taken to the airwaves to advertise for clients. In this situation, I had to talk with both these jurors about whether there was any potential for conflict in their versions of events. So, I mean, I'd have to sort through all of that, but I'm more than happy to talk with any of these other jurors if they feel the need, but I'm not beating the bushes and not knocking on doors.
You also economized on Murdoch like so many other people. You have a movie script about this trial. Has it been picked up? What is it about? When can we expect to see it?
Well, I wanted to go to film school instead of law school, and I took a wrong left turn. And so I've never got to be the film director that I had intended. I just get to direct traffic in courts to some extent in trials, but that's not really a way to get your yah-yahs out. So this case has offered the opportunity for me to begin writing a screenplay, which is unfinished, but I have the benefit of 4 years of involvement, a degree of omniscience in a view of this thing. I've collected evidence, and obviously, as many people have commented on, I became famous for sitting in a courtroom for 6 weeks and burned up about 40 legal pads. So,
and also this is going to go on for a long time. So either you write one script and then be prepared for a sequel, or you write a 4-hour movie. It's going to be a long ass movie either way. What about that media? Go ahead.
I'm sorry. Yeah, Joe, you did have a front row seat during the trial, and you were also mixing and mingling with the media and giving interviews during the trial on different networks. And I have been asked this question frequently, and I want to ask you the question. If you have an opinion as to how the media coverage impacted the Murdoch trial.
Well, I've been in a lot of, as you have, been in many high-profile cases. The greatest fear is that jurors don't listen to the judge and go home and watch TV. So that's number one. They might find out in the 7 o'clock news about evidence they never got to hear that never got to come in. But the media changes things. It has forever. It happened. It changed things in the Monkey trial, the famous Scopes trial. It changed things in the Shepard trial, the famous F. Lee Bailey case. Mm-hmm. It causes lawyers and judges to act differently. Mm-hmm. It leads to more florid closing arguments sometimes. It leads judges to commentary that they would not normally give, but feel the pressure of the media. It most especially represents a danger that a judge considers the public opinion that will come from the media coverage in ruling on evidence. So, I mean, it represents dangers to the process, but because of the First Amendment and because trials are supposed to be public events, there's just no choice. We have to deal with it, and lawyers just have to behave. But I have to say, when a good lawyer zones out that media, they focus on the witness, and it's tough enough being a trial lawyer because you've got to be there ready to either ask questions, you're listening to the witness, you're watching the jury, you're watching 12 people looking for body language, looking for reactions, you're watching for the judge, you're you're multitasking in a way that is incredibly exhausting that people just don't appreciate about lawyers. What we do is hard, even though we're just sitting.
We're thinking about so many different things, but for us as lawyers, because of what's at stake for our client, I'm talking about defense lawyers, I think it might be an easier practice to zone out, like you said, Joe. But the concern really is, as you said earlier, is the other people in the courtroom. Sometimes jurors even feel like if there's a camera on them, that might impact some of their deliberations. The judge, when I watched, Jim, you can take the fifth on this, but Joe, when I watched the sentencing of Murdoch, and this is not just me, I have friends who are former prosecutors, we all cringed at how overboard he went and how personal he got, Judge Newman, with sentencing Alec. I mean, there was a lot of things that he said that were completely unnecessary and that I've never heard in 24 years of sentencing hearings. And so when you say that when there's a camera present or there's media present and the spotlight is on a judge, I mean, do you think that some of that show was because of that?
Well, I have a lot of respect for Judge Newman, and I'm not going to say what I think.
Okay.
I will let people come to that conclusion, but
can I say that that's what I think?
You may, and because you practice in South Carolina, but
right, exactly.
I think that we all have to guard against excesses. Can I tell you a quick funny story?
Sure.
25, 30 years ago, we had a hit and run case here in Columbia that resulted in the deaths of 4 young teenage kids who were hit by this mystery truck. It resulted in the arrests of 2 defendants, one of whom I represented, and it was a trial against Dick Harpootlian as the prosecutor. And it was the very first, we got the word from our Supreme Court that it was going to be the first, they were going to allow cameras in the courtroom as a judicial experiment to see the effect of media. And so there were cameras in the courtroom in South Carolina for the very first time in history. And it was covered from gavel to gavel, as they say. And then at night, it was on our public education television station with commentary by lawyers. And Mr. Harpootlian and I were trying this case. And every time the judge would say, all right, I want the lawyers down front for a bench side conference. The first time we went down, I noticed the box that our little short clerk of court back then had to step up on to get to the judge, to hand papers and to consult privately. And so every time for the next 3 weeks of that trial that the judge said, I want the lawyers down front, I would step a little livelier than Dick Harpootlian so that I could get down to step up on that box so that I was at eye level with the judge, and the judge and I were then looking down on Mr. Harpootlian and the other two prosecutors, and Dick never got it. So I guess this is the first time I'm revealing that little lawyer trick. But it elevated me in the public view. It elevated me, although I didn't get any rulings from the judge. It didn't make any difference to him. But I did I won a mistrial in the first case, so we had to do it again, much to Dick's chagrin. But it does lead to little lawyer uses of the media perspective.
Sure.
There are all kinds of little playful things you can do, but ultimately it's about the result of the trial and your efforts as a lawyer. So you have to put that in the background. It's a Chinese curtain, so to speak, backdrop, but it is distracting.
But, you also the power of media is tremendous, and it's about understanding whether it's good or bad for you, what the narrative is, and just trying to manipulate it before it manipulates your client in your case, getting the upper hand.
It just seems, South Carolina always makes the news for the wrong reasons, but we've had some really high profile criminal cases like the Susan Smith case where she drowned her children and blamed it on a black guy that carjacked her. And that
never existed. And I was a commentator in that case.
And so that was probably one of the first in my memory of a national coverage of a South Carolina case. We've had, the Dylan Roof case where, that was awful, where he went in and massacred.
I forgot that was to South Carolina.
Yeah. And then, we had an officer, what's his name? Slager, who basically executed a fleeing person after a traffic stop, and that was a pretty big case here.
Yeah, so where is the church that Dylan Roof?
It was Charleston Mother Emanuel Church. It's right in Charleston.
Okay.
Yeah, and it's a beautiful church. It's historic and beautiful people there, and who can ever forget? At his bond hearing when the victims family members and stood up and said, we love you, we forgive you. It was truly, truly remarkable.
But Jim, that you make a point there that it should not be lost. The magistrate, as I recall, I think it was that case, the magistrate required the defendant, Dylan Roof, to attend the bond hearing, though he had sent the message through his lawyers he did not desire a bond hearing. But the judge required him to appear and then made a speech.
Right.
And I think there were some ramifications of that.
Well, as we're just wrapping things up here, Joe, I just wanted to say on behalf of all of us out there who do like to imbibe every now and again, thank you for the advice. I'm certainly going to pass all of that along to my friends. And thank you for coming to join us on the podcast today. We met very briefly at CrimeCon. It was a pleasure, but I never really had a chance to really hear your story and the things that you've been working on. And, as just a random dude here in Texas, I'm extremely impressed. And again, thank you for sharing all of your stuff with us today.
Man,
Joe has been a good friend. I met him in March when I went down to South Carolina. He was a Southern gentleman to me and very hospitable. I'm not very well liked in that area because of my opinions, but Joe was very kind, and we get really good laughs. And I appreciate Jim for introducing him to me and for you to join us today. I hope that you come back because there's going to be a lot of conversations that we can have with you, Joe.
Well, happy to do it. Hey,
thank you for joining us. And
find me another cup.
We'll get your new cup. Thank you for joining us, and we will be back next week with another great episode of The Presumption. Please subscribe, find us on all the podcast platforms, and also find us on YouTube if you're visual like me. And so, Jim, until next week,
we rest.
We'll rest.